probably this is the latest ever discussion on the subject privacy and competition. But I believe that having in mind the current developments on the competition markets and generally regarding the possible new regulatory steps that we expect at European level, this discussion deserves attention, a lot attention, and I think the subject is really, really appropriate and could be also touched upon also in the previous session as well. Many wonder, do really privacy is a competition problem? And now we have a really pioneering case with Facebook in Germany. And we have all written really wonderful academic papers in this respect. I really enjoyed your latest academic inputs on the subject matter. And I really appreciate that Simonetta could join the discussion came from Switzerland extra for this panel, and Ioannis from Greece. And it's really a great honor for us. This is probably the only proportionate panel in this evening, since we have two ladies, and I'm really happy for that. So let's start. I must say in the very beginning that I got inspiration for this topic from your draft paper, Aline, and it was actually your suggestion. Where originally I said, when privacy affects competition, and then she called me. She said, "Bencho, maybe you should rephrase it to be more suitable, and maybe you should say when privacy meets competition." So, because of you, I have rephrased it. What's your thought on this? How does privacy affect competition? Privacy meets competition.
Well, I think there are various interaction points, and maybe to come back to your first question, is privacy a competition problem? And I think the answer to that is, well, it depends, and it depends exactly on one question, and that is on whether competition concerns lead to or aggravate privacy concerns. So we shouldn't try to make privacy generally a competition concern. I think we shouldn't generally make GDPR enforcement a matter for competition authorities, but I think there are specific instances where privacy becomes a matter for competition, and that's, for example, in the merger context. If you have companies competing on privacy, even if it's not the main parameter of competition, then a merger can lead to, well, a worse privacy outcome. Or also, if consumers face a dominant firm and have to make choices about their privacy, there may also be a privacy, there can also be a competition problem if consumers don't really have the same kind of choice to give their informed consent about how their data is used. So in those cases, we have an interaction. That doesn't mean that always it's just a matter for the competition authority to look after it, but they should certainly be aware of those matters and try to, well, grapple at least with the kind of competition part of it that's contributing to the privacy concerns.
Many thanks. The same question to you, Simonetta, maybe with one supplement. Is the GDPR really in favor of having more competition in Europe?
Thank you. Question? Ladies first, I've seen. Oh, sorry.
It's already on.
It's already on. Okay, so we get Pete.
And it's only for you.
Thank you for the very interesting question. Well, I don't think it's really possible to say generally whether GDPR is in favor of competition or not, because, well, we have to go back to understand what the GDPR is. GDPR, as you have also written in your paper, is a sort of minimum level of protection of a fundamental right. Okay, so it was not the purpose of the GDPR to create markets for privacy, markets for data. It was not the issue. And then, of course, that's a problem with the GDPR, I think also because they could have done more to create markets, well-functioning markets for privacy. It was something that was not considered at all. It was this part of the economic approach was totally disregarded by the ones who have been working on the GDPR, perhaps also for good reasons, because they didn't want the economists to jump in and perhaps scramble eggs. So they really wanted to keep it in the area of the privacy. So I don't think it's really the purpose of the GDPR. I think the GDPR actually is technology neutral, but it's not value neutral. And that's extremely important. But when we think of slavery, things or the issues we have, many things would not happen because of the GDPR, because there are values there. And there are not only values, but there is also a sort of direction for us all in the way that we want that economy to develop. And also there is another thing very important, there are incentives for privacy-enhancing technologies. So there is quite a lot. So tangentially, I would say, yes, they affect markets. It's not the purpose of the GDPR to decide how much competition there should be.
Okay.
Yeah.
Many thanks. Ioannis, you're advocating for more taking into consideration of privacy as a concept within the competition enforcement. Why is that?
I mean, there are different reasons why we should care about privacy from the point of view of competition law. As it was mentioned before, privacy can be a competition law problem in the sense that the lack of competition in a particular market might lead actually to reduced privacy. But this is not the only reason why we might have a privacy problem. There might be other sources where actually we have a market failure that could lead actually to a loss of privacy. For instance, you can actually have a lock-in effect of certain consumers to a particular, let's say, platform. That could be possibly a competition law problem in some jurisdictions, those in particular that have rules on economic dependency or relative market power, like in Germany, not in other jurisdictions where actually market power is much more narrowly defined. You may actually have asymmetry of information problems that could actually also lead to loss of privacy. And asymmetry of information might actually be possibly a consumer law problem, or it could possibly also in some competition law regimes be also a competition law problem in case the asymmetry of information leads to is a source of market power. So I think it's from my perspective, because actually we can think of the lack of privacy as a possible market failure, and therefore not break a little bit with the approach that the data protection law has been inspired from, which is more a fundamental rights perspective, Article 7 and 8 of the Charter of Fundamental Rights. If we take a different approach, a more, let's say, market failure perspective, there we can actually see some room for privacy concerns in competition law.
Many thanks. I think also in the similar direction, maybe would go Wolfgang. Why do you consider actually that the GDPR is sufficient to deal in competition cases? Is it true, my understanding of
the GDPR is sufficient?
Sufficient when dealing in competition cases?
No, I think if you have a privacy problem, so the question is whether competition law can really take into account privacy problems. So my point is that this is a discussion about the Facebook case, and the most counter position.
I thought maybe we come to the Facebook case in the second room, but you can touch upon even now.
No, so the point is about this separation approach. So it's the discussion whether competition law should only focus on competition problems, and privacy law and data protection law should focus on privacy problems. And therefore, if there's a privacy problem, then this is a matter of privacy law. This is a very important position. Also, the European Commission exactly had this for a long time. Now, the question is that these two different kind of laws, they are interacting with each other, and behind these laws are market failures. This was already mentioned, and we have information asymmetries on one hand, and we have competition problems, and these market failures also are interacting with each other. So we have often effects, especially in the digital platform markets, where we have effects, negative effects on both privacy and on competition, which are jointly caused by both market failures. And I think this is the real important problem, that in the digital markets we have both information and behavioral problems, and therefore the consumers cannot really deal with privacy policies, are overwhelmed by this. And at the same time we have the competition problems. And the problem is now, what is now the division of labor between both different kind of policies? And the point is that you cannot really separate this anymore if these are intertwined in that sense. And this means, from my perspective, that competition law, I think, has to deal with privacy problems if they are caused by competition problems. I think this is also what you meant. And then they have to deal with this, and this is on one hand because data protection law cannot do this. It's a privacy problem, but data protection law cannot deal with this because they have not the remedies and they have not the expertise for really making market definition or for really dealing with competition problems. And they also really only, as you said, it's about a minimum standard of privacy, but we would expect more than that. Yeah, and therefore data protection law cannot do this, and so competition law has to step in these cases, and mergers is one, and the Facebook case is another, but we can also think about cat house. I think cat house is an interesting thing. If firms in a certain industry really make a horizontal agreement about privacy policies, for example, which might comply with GDPR, but it's still anti-competitive, then this is a competition law issue, and only competition law can solve this.
Many thanks. Sebastian, you're a competition lawyer. From your point of view, not including mergers, is privacy really a competition problem? From a practitioner's point of view.
From a practitioner. First, thanks for this question, and I highly agree with W.Kerber's meaning of there's a separation between competition law at once and privacy law at the second. But it's not separation, it's overlapping too. And overlapping in, and this is the practical problem, overlapping in a meaning like there could be a privacy enforcement and an antitrust or competition enforcement both ways. And both ways because of this. When you take a look at the privacy law nexus, I'm using this nexus term because of the Federal Cartel Office's saying this. The privacy law is giving a nexus for this whole fundamental right concerning privacy. But these are not fundamental rights concerning privacy. It's the same fundamental right concerning freedom of choice or freedom to get informed. And these fundamental rights are involved into competition law. And that's why there are possibly two ways of enforcement. And the first way, it is a little bit mixed up with this Facebook case, is taking privacy law directly and trying to do antitrust enforcement via data protection. This was the Facebook case. It ended positively for the Bundeskartellamt in that way that the result was confirmed by the BGH, by the Federal Court. But I disagree. I'm not sure Andreas Monasterio. I disagree in that way that the court confirmed the theory of harm. This is not true because the court disagreed about the theory, about the basic theory, and this was not like taking privacy law directly. We are just enforcing competition law. And competition law could, and this is the way back to my first saying, competition could be fundamental rights enforcement.
Many thanks. We officially opened the Facebook case. We couldn't avoid it. That's absolutely
Sorry.
okay. Please.
I'm not about the Facebook case, but about what was mentioned before, because I think it's quite important to understand the complementarity of competition law and privacy protection. If you actually have an opt-in, a default opt-in case, as actually, for instance, we have in the US, where, I mean, with the exception of some states, you don't really have a protection of privacy. Then in this particular case, we have a possibility to move to a default opt-out, as actually we have in Europe with the GDPR. So that will enable a person not to actually have their data harvested and collected without actually their consent, right? And this is really, the position we have here. But that doesn't necessarily solve the problem. And what could be the problem? The problem is that they are, harvesting this data without necessarily paying the price for it, right? Or the just price for it. Okay, let's use this term. And that is actually why, the reason why this is happening is this asymmetry of bargaining power that you have between the platform, which actually collects this data, and the individuals, right? So from this asymmetry of power, actually, this is something that data protection law cannot solve by itself, because this happens also in the context of the GDPR, regime like the EU, and therefore you need in this context maybe something else, another type of remedy. You can call it actually competition, could be competition law, it could be actually a different type of tool that will possibly, solve this particular problem and enable the market to be established. In which case, some people that could be more privacy oriented will prefer to pay for the use, for instance, of Facebook or Google, and not for their data to be harvested, and other people actually, to be paid for it, right? So in a certain way, I think this is the lack of this market is what actually is the source of the problem, and competition law might actually help there.
I really appreciate your way of reasoning in your latest paper and explaining that in the context of what does it mean price in the context of prices, like exploitative abuse, and in the context of data protection. But let's move to the difficult issue of theory of harm. As we know, in the higher regional court rejected that notion, and we have basically confirming the abuse of dominant position by the federal Supreme Court, but with a slight of different reasoning, so to say. What's your view on this? I believe you have read to the last letter the reasoning of both courts. Where do you see the real harm on competition in this case?
Well, yes, I read the decision. So I read the decision, and of course, I thought it was surprising and quite exciting. Before going to the theory of harm, I would say that perhaps 3 reasons why I really liked this decision. Well, first of all, that it's really pointing us in the right direction. Reframing the debate, it's not just about...
You're talking about the latest decision by the federal...
Yeah, you say the Oberlandesgericht. We are still discussing the intermediate?
Yeah.
Yeah, okay, so before the...
No, I'm talking about the boat, but simply
so
we have different
I'm just
reasoning.
thinking of the federal, the last one, okay? The one confirming the Oberlandesgericht. So, I thought, well, of course, it was quite tricky. It was surprising. And so that's why I'm saying it's putting us in the right direction, because there was the discussions, we discussed it also with W.Kerber, it was the discussion about an abuse of dominance based on infringement of the GDPR. That was a good idea based on a German precedent, not from the digital age, of course, perhaps in a controversial way. And it was leading us in a way, perhaps that was not very helpful in the end. Whereas now, really, we are looking at the real issue here as the issue of choice. Okay? So the issue of choice would mean it's even beyond consent is the choice. So it means you are dominant. You need to leave the possibility to consumers to decide the level of personalization. I mean, so it's really, so what type of services you want. So I think it's really, quite, really looking into the future, looking really what's the problem. And also President Andreas Munther again said, what's the real issue here? It's about the fact that we have to go to the core of the problem. The core of the problem lies exactly there. And so it's really pointing us in the right direction, mentioning what's really important, so the possibility of choosing, and the possibility of choosing, really exercising our real right to privacy, which means the data to the level of intrusion that we want, level of creepiness, basically. So we can really decide about it, and we should really decide it, and the undertakings in dominant position should really offer the possibility of choosing. So that raises quite a lot of interesting questions, of course, and that would be, so it's not only elegant, it's forward-looking, it's pointing to different perspectives, and quite a lot of thinking needs to be done now, I think, based on this decision.
Is it imaginable that maybe the Hellenic Competition Authority would address the similar question? I mean, it's not a polite question. Maybe some other national competition authorities.
Theoretically speaking and hypothetically, possibly. And I think what was interesting, actually, what was most interesting in the Facebook case was actually the remedy, I thought. Because what actually really happened there is a form of ecosystem data breakup. This is how we call it. Because the remedy, without necessarily doing a breakup, because this is obviously going to be impossible for political reasons for a small authority like ours to do. It certainly enabled the, it somehow broke the ecosystem of Facebook, which is a third-party ecosystem to a certain extent, because you have actually independent companies that are participating to the ecosystem that create all these, where Facebook put their cookies, etc., where they were harvesting data, and for these type of data harvests from these companies, there was actually this requirement, the idea that this was actually anti-competitive. So from that perspective, there was a separation between the core, let's say, Facebook services and those actually that were not owned by Facebook. And I think that was an interesting remedy. With regard to the theory of harm, I would say, the difference I would see between the Bundeskartellamt case and the the last actually judgment, is that the Bundeskartellamt case, interestingly, went to enforce competition law, but actually with regards to the theory of harm, really borrowed heavily, and actually did not even borrowed, actually did actually a GDPR type of analysis, claiming that.
Jonas, just short, do we really need proof of harm in this respect when it comes to privacy? That's also a relevant issue, I believe.
It was actually a competition law case, so you have actually to prove some form of harm, right? From that perspective. So, and I guess in privacy too. There is obviously some form of harm to establish under the criteria of legality are very different in privacy and competition law. Well, in this case, actually, it's quite interesting because the Bundeskartellamt went and implemented the criteria of legality of privacy law when they were dealing with a competition law case. And I think what the judgment of the court tried to correct is that they said, okay, you might actually be inspired by privacy principles when you are trying to determine a theory of harm based on privacy in competition law, but it has to be a competition law theory of privacy. So, and I think that was, the main difference between the two cases, at least the way actually I understood them.
We all heard that maybe we expect at some time that this case will land in Luxembourg, who knows. Aline, you have a clear view on the theory of harm, I believe.
Yes, and I would say, you asked what's the harm to competition, and if we talk about exploitation, you don't need harm to competition, you need harm to come from the lack of competition. So, and what also the Federal Supreme Court has now said is basically their theory of harm, is related to choice, and they say that if there had been a more competitive setting, they would have expected more privacy-friendly choices to be provided in the market.
But in your latest article, you found out that there is simply no competition on privacy, if I remember well.
Well, I think the fact that we have really little competition on privacy is driven not just by competitive failure, but also by the lack of incentives to actually compete on privacy. But I think the lack of competition can make that worse. So so the question is, if there are more options in the market, does that already give you the choice, even if those choices are all equally bad? I think if they're all equally bad, well, then the choice probably doesn't really give you that much, but you still have. But I think in most markets you see slightly differentiated offerings, at least. However, I think everybody's now talking very positively about how the Facebook case has turned out, and I think everybody kind of likes the Federal Supreme Court decision. I think there are still some open questions there. So they also, because they not only talk about exploitation, but they also talk about exclusionary conduct. And they somehow link the two, but to me, it's not really clear to what extent one requires the other for this to be a competition case. There's kind of a slight, well, I think some people are suspecting this, but it's not really clear yet. And well, maybe, you know, the case may be running for a few more years. But at the moment, it's kind of in the air. So there's somehow some exclusionary effect on advertising markets, but there's no evidence. And I find this pretty tricky because basically the Bundeskartellamt case was a pretty different one. So now we are running this case with really little evidence on what the current theory of harm is. And there's also not much clarity on how the two different theories of harm interact. And that's one of the reasons why I think the Facebook case is doing great in terms of, you know, attracting attention to the problem. But I also have lots of sympathy for this kind of more UK approach of having a market study that is more targeted at bringing out structural problems, which I think we haven't really done yet in this Facebook case. I think we have a slight suspicion that other players might fall foul of the same problems, but we don't really know yet. Kind of, we first exercise the whole thing with Facebook, and then kind of when we see the results, I guess we'll see where else we can apply them to.
Many thanks, Celine. Irrespective of the reasoning in the board decisions, the same question to Wolfgang and Sebastian. Where do you see the convincing theory of harm in this case?
Yeah, I mean, the theory of harm, I think, is clear. There are two harms. The one is the harm to privacy, and the one is the other to competition. And the one to privacy is very clearly that because they are bundling this, and the consumers have no choice and have to accept or have to consent to the bundling of all this data and these very comprehensive consumer profiles.
But Wolfgang, maybe the consumer likes it. Who knows? I mean, I don't have the feeling that many consumers are complaining.
Yeah, but the point is that they have no choice whether they like it or not.
Okay,
and there might be some they like it and others they don't like it. And that's exactly the point.
I'm not saying that Facebook is a perfect machine. But I don't have the feeling that many consumers are aware that they are, at the end of the day, worst by using that machine.
I mean, this is a second market failure. This is an additional market failure. And that was my point, and we have to look at both at the same time. And that was also a point of the Bundeskartellamt. They also mentioned the problem of information problems and that they are not aware of this. But this only strengthens the argument. So the point is that there are, and this was also the point at the Federal Court of Justice, that they said there are two groups. There might be two groups of consumers, and one they are private sensitive, and the others they are not. And the private sensitives, they have no choice, and therefore there is consumer harm. And I have no problem as an economist to say this is negative for consumer welfare, and therefore I can bring this into a consumer welfare standard. It's not a problem. And so in that respect, we have an exploitative abuse. And for exploitative abuse, I don't need any kind of negative effects on competition. Yeah, it's negative for the consumers, and this is sufficient. as for an exploitative abuse. The second is, and linking this, because, to the question whether Facebook, and we also talk about Google, this would be a similar case, that they get through this bundling a lot of more data, and therefore have a data advantage. And this is now the discussion we have now in the last more than one year about the digital market, about the digital advertising markets. And you only have to look at the CMA study, and they make very clearly exactly the theory of harm, that these kind of data advantages lead then to barriers to entry and lead to a distortion of competition on the advertising market. So in that respect, these are the two theories of harm. The question is, to what extent can you really prove it? But this is a theory of harm. What I would like, but also to emphasize is, when we go back to the Federal Court of Justice, because this was here discussed a lot, I thought it very important, this idea that we have this constitutionally protected basic right of informational self-determination. This was the argument, which is the same as we have privacy as fundamental value at the EU level. And what the Bundesgerichtshof says is that this means that the consumers have a right to substantially participate in decisions how their data are used. And this substantial participation in the decision, this is not possible anymore through the behavior of Facebook. That's the argument. And therefore, this is, in my sense, primarily still an exploitative abuse case. Yeah, and therefore, and this is the main argument, and I think this is a very good argument, therefore, I think this is a very convincing case, and I think therefore this might also be, I think this will go up to the European Court of Justice. This then might also be a violation of Article 102, and this is discussed. Yeah, and I think this is very important. The point is now. The question is, there's one specific additional paragraph in the decision of the Federal Court of Justice, and this is that the social media platform of Facebook is not only dominant, but is also somehow unavoidable for part of the population, so you cannot avoid it anymore. So it's something more than dominant. It's a kind of an infrastructure-like communication platform for the society. And then the court says this leads to special responsibilities also for the conditions to access this. Yeah? And I think this is interesting that this is perhaps more than dominance what is required for this also kind of remedy. And I think this is perhaps interesting thinking about more what does this mean.
I absolutely agree with you. I'm just laughing because I wish one day the same way of reasoning when it comes to open data in Europe. But that's completely different subject. The same question to you, Sebastian. Theory of harm. Do you feel convinced by the recent judgments?
Well, this is about my feelings.
Feelings matter.
Yeah. Yes, but first, yes, but in 3 points. First, I really favor with Aline's thinking about privacy as a quality matter. I understand it as this. This is a really, I think this is something we should always recognize. And it had been a little bit recognized by the Higher Regional Court of Düsseldorf, I suppose. But in the wrong way. The Higher Regional Court said something like, everybody is free just to choose another platform. And this is something thinking about quality and privacy aspect. This was overruled by the Federal Court, but it was the thinking based in Section 19 in this as-if concept, like comparing the market with another narrow market. We don't have narrow markets, as you said. It's just a problem like where's the market just to compare. This is the first. And the second, now back to your question, I'm convinced in that way that the BGH just fostered its this recent case law about this abuse of conditions because of maybe some people know VWL Gegenwert 1 and 2. These are case law from several years ago. It dealt with this kind of abusive of conditions in terms and condition cases. And it was used by the Bundeskartellamt in founding the Facebook case. And the Facebook case started in this kind of infringement. Data protection law is competition law infringement. And now the federal court said it is just not necessary to assess this question. It is more necessary to ask what is competition in that way and what is based the balancing of interest. And the balancing of interest thing, this is the result of what I would say is the theory of harm we should work with, because this is the question: what is the interest we could take into this balancing process? The privacy interesting, maybe not, but maybe the personality processing, like the freedom of choice. This is my theory of harm I would define. And you asked something about this, what if the consumers doesn't want, or just it's just not a problem for them, just they want to be exploited. This is something I want to maybe think about. This some German federal or constitutional court cases. We have some case law in this waiving up our constitutional rights. We have Zwergenweitwurf, Bundesverfassungsgericht. It is people, they're saying, throw me, I'm just a small guy, throw me because of the fun of other people. And we have the discussion about this. Is this against fundamental right? I guess we could take a little bit of these arguments to our Facebook thinking and think about whether it is possible to waive up constitutional and fundamental rights in these Facebook cases, in this theory of harm, and that will lead us to a balancing of interest where it might be not possible.
I really like the reasoning where they said that also by the way of processing data, also the competition on the market is affected, because the new entrants, they don't have the equal level playing field when it comes to developing new product or whatsoever. With a view on the time, do we have maybe comments, questions in the audience? And I see Oshrit, as I already said, the co-author of the paper with Professor Michael Gal from Tel Aviv or Haifa,
Tel Aviv.
pardon.
Haifa and Tel Aviv.
Yeah.
Yes.
Please.
Thank you. Actually, I have two notes more than comments, but I would love to hear your view. One of them is a little bit commenting about the small dialogue you had, Pencho, with Wolfgang about Facebook, as an example. And you were mentioning that the consumer can choose whether they want to give whether they want the trade-off of the data versus the services. And I want to be a little bit the devil's advocate here, and the consumer always has a choice. So if they choose to give Facebook the data in exchange of free services, I think the consumer always has a choice. But again, it's being a little bit of devil's advocate. And the second point is that I think it's really important to emphasize that if Facebook is being taken as the only use case, as online advertising, social media, and all the examples that people mention here, I think it's really dangerous to look at Facebook as the only use case, because I think Facebook specifically implies poorly on the ad tech ecosystem. And all the consequences as a result of Facebook's behavior, the entire ecosystem should pay the price. And I think at the end of the day, that empowers Facebook on the competition playing field. At the end of the day, when you explore the entire value chain and you see how these types of regulation versus court ruling, at the end of the day, not necessarily dispowering Facebook, but actually dispowering the ecosystem behind it. There was a note, but I would love to hear your view on that. And maybe a second small note that refers to the first question that you were asking Simonetta about, was there any positive effect on competition that GDPR creates? And despite the fact that my general notion is that the GDPR did empower the big players, I still think that the GDPR created new markets and new ecosystems, exactly the points where you mentioned that not necessarily. GDPR created new professions, and it created new ecosystem for privacy tools. So I think that's worth mentioning as the positive effect on competition. Beside that, I'm the advocate of exactly the opposite, so that's it.
I think you have enough inspiration for the comment of Oshrit, but maybe we take one more comment from by Torsten, if it's possible. Short, Torsten.
Of course, as always.
Every time.
As always. So, for good reasons, the Commission made the decision to take privacy data not as intellectual property. But on the other hand, we are dealing like with intellectual property. So when I'm handing over my data to Facebook, it is on the positive side of their balance. But when I'm taking in consideration that I can take it back, is it not that I'm borrowing my data to Facebook? Should it be not done on the negative side? So can we not fix that whole issue by just a simple change of international accounting law saying, hey, if somebody's giving me data, is it not an asset? It is a loan. Because I have to give it back. That will generate an insight to make decisions on as less data as possible, because otherwise my balance is going down.
Yeah, of course.
I would like to briefly take up one point from you and also to you. So just very briefly on the question of does Facebook actually reflect poorly on the ad tech industry? I believe it doesn't. I believe it's a very good example of how the ad tech industry works, and it may not even be the worst. I mean, people have been looking into data brokers for some years now and haven't really come up with a fix. But somehow everybody who looks at it goes like, ooh, this is really bad. I mean, there are companies who just live off data and selling really detailed profiles about pretty much everyone on the planet and trying to kind of make the most money out of it that's possible. So Facebook is monetizing that quite cleverly, and a lot of people in this ad tech stack are dependent on Facebook. Yes, but I'm not sure the world becomes a worse place if we take some money out from that and go from very much targeted, personally targeted content to, for example, more contextual advertising. And I have some hope that we see some actual effort in that direction, maybe also with the upcoming regulation. And the other point, should we somehow fix the balancing sheet? I think, just a very brief point is, I think people don't necessarily primarily want more money for their data. I believe this
that was not my point. That was not my point.
And they don't. Facebook wouldn't have to give the. I mean, I think it's not about money. I think it's about thinking how we set incentives such that data is used in a way that benefits consumers rather than exposes them to more risk. And I think for that we can, there are a lot of potential mechanisms we can use. But I think maybe Yannis can also come back to that, because maybe I think you have a slightly different view on that. I think it's not primarily about kind of getting markets to work such that consumers get more data, get more money. I think they actually want more influence and should have, and their interests should be more at the center of what happens with their data. Or maybe we're on the same page.
Sorry, I guess we did not understand us here completely. It's about the evaluation of the company. It's not about the money for the consumer. The stock market is driven by data. So if this is not on the positive side, first of all, the liquidity of these evil folks is going down dramatically. Yeah? And secondly, that is generating a totally different incentive. It is saying, be careful with data of humans, then your balancing is going up. It is not about giving money to people. It's about evaluation drivers of companies.
Okay, please let's focus maybe on these remarks by Oshrit and close the discussion slowly. I would start with Ioannis. Maybe you can comment on the issue, on the
different
questions,
issues? Yeah,
for sure. And maybe at the end, like a final remark, do you believe that the current coexistence of the GDPR with the competition framework is enough to deal in the future more in a more concrete way in cases like Facebook?
all right. So with regards to the first question, I think from you, so I think there is an issue that we have to take into account is that the consumer doesn't have, the user actually, doesn't really have knowledge about the value of their data. They don't really have information about what's going on the advertising market between basically Facebook, Google, and the advertisers. So this is really something that is certainly missing, and to a certain extent might be an important problem if we actually, want to have a fair exchange. And, I bring again the issue of fairness. I think it is actually what probably also might motivate. It's not just an efficiency story. It's also, I think, an issue of fairness. What might motivate also this type of approach. Secondly, I would say that what is probably the problem in these markets is the fact that the current situation might lead to to mistrust, and to an institutional problem for the specific market. Which means that the consumers will have more difficulties to, provide their data, in particular, to newcomers, because, Facebook and Google, they have already their data, so, they will not necessarily, it's a marginal, utility for them to provide a little bit more, but, if it's a new player, why should we provide the data there? And I think, to a certain extent, there is an issue of legal code that we need actually to take into account. I mentioned the term legal code, taking this term from Katerina Pistor's basically book about the code of capital, because I think what is really happening here is, we have not established at the beginning of this industry the right legal code, which was to provide property rights on the data. So what actually we enabled was a sort of, possession of that data provides. It was enough. And this is exactly what led to the fact that we had, the emergence of these giants with important network effects and learning effects. And I think the learning effect is much more important than the network effect here. And why is that? Because the more data they harvest, the more market power actually they get, the better actually they make predictions, and therefore the more valuable they are in the advertising market. And this is basically a circle that continues. And I think here we did not have the legal code at the beginning. So the GDPR, and I agree with a paper by Michal and
Oshrit.
Oh, exactly. I think they mentioned something which is absolutely, I think, right. At least there is some evidence that is happening. So the GDPR possibly might lead to reduced competition to a certain extent. However, I think what is important here is not to have a little bit of a natural market idea, and I take a little bit of that from Michael Harcourt. We cannot compare that, because what is the counterfactual here? I don't think really the counterfactual here is a market which is unburdened by data protection regulation. That's the wrong counterfactual, because the counterfactual here is a market where, in case we did not have the GDPR, actually the market might have collapsed because of the fact that consumers would not necessarily have trust in providing their data. So I think we have to be very careful in the way we assess the competitive effects of the GDPR and the counterfactuals actually we have in mind when we write something like that.
Clear statement. Many thanks, Ioannis. Simonetta, maybe we continue with you.
Sorry, the question?
The question would be your final remarks, and maybe you can also send some clear messages for some future cases. Does this framework suffice to deal with potential new cases like Facebook, or you see a problem somewhere?
There are always problems. But the thing is, I think, as I said, this decision by the German Federal Court has been very helpful. As I said, as an academic now, I already think about it, and I think it's showing us, as I said, interesting direction. I think, as W.Kerber, many others here have said, we need to think more of possible intertwined effects. Okay, but also positive. There are some interesting dynamics going on. For instance, when you think about access to data, okay, that would be, of course, one of the remedies. Okay, and then, of course, you have to think about how you make it. And I'm not sure that the GDPR is going to be an obstacle to that, because, of course, the GDPR, as the coronavirus has shown with the apps, could actually be quite flexible. There is a public interest, perhaps, also that the competition authorities can refer to say, well, you need access to data because, for instance, the case of Google search engine, as the CMA has actually written in the big Bible, their report on digital platforms and online advertising, you need it. So what type of access to data? And they've said, okay, you need access to click data, et cetera, and then they can say, well, it's covered by the GDPR, it's perfectly compliant with the GDPR because of the public interest. At the same time, the GDPR is telling competition authorities how to do it, because the GDPR isn't only about consent, not at all. They were just one principle, that's lawfulness. There is the whole array of other principles after that, in which I think the perspective of competition authorities and data protection authorities could actually come pretty near, and we need more collaboration and thinking in that direction.
Many thanks. Professor Kerber, Sebastian, and we finish with Aline at the end.
Yeah, I would like to continue. I think also, as also Johannes had said, both laws are complementary. And I think we have to much more analyze the interaction between these both laws. So one, also what you can mention is data portability. Data portability, really, we are discussing right now enhancing this for promoting competition. But this is part of data protection law. So in that respect, you have real interaction effects between these both laws, and we have to think about how we are dealing with this on both sides. And what I think is interesting is you can look at the remedies of Facebook case. We have not talked about the remedies really. Do the remedies really work? Because it's not really an unbundling. You only get an additional consent. So the consumers have to consent. It's not really an unbundling.
But
so if only
maybe to add to that, will Facebook be at all in a position to function if we implement these remedies?
Certainly, why not? It's not a problem at all.
I'm not sure. How will they know what I was looking for the day before? How will they know that potentially Aline is a friend of Simonetta? How will they find out that I am preferring Nestle products more than, I don't know. If we really unbundle the whole...
I think it's not a problem.
They can buy it's technically not possible. What is technically not possible?
If what he said will be, if they try to implement that, the whole policy engine of Facebook will not work anymore. No chance.
Why is that?
Because it is how it is implemented. That's tech stuff, not law stuff. They have several layers, and one of these is exactly what he said, is these consent management. And this layer is not like a vertical layer, it's a horizontal one. And so when you're not able to handle that in that way, how they're doing that today, all the other layers have no fundament anymore. It will just collapse at once.
We're not talking about the core Facebook business.
Oh, no.
I mean, we don't care about the core Facebook owned, basically.
But what he is talking about is one of the core functionality of Facebook.
Well,
it is code.
Facebook used to work quite well even before it implemented those features.
Sorry for interrupting you. I didn't want it to go in that direction. Just was, please, Professor Kerber, please continue it.
No, my point is that the remedy is only giving the consumer an additional consent. And if not enough consumers reject this consent but accept it, then there is no real effect, for example, on the exclusionary effects. Then Facebook has the same amount of data than before on the advertising market. So this does not help the exclusionary effects. It might help the exploitative effects, and that you have enough choice, but only if really the consumers are not suffering from the second market failure. Because if they are not well informed and they are overwhelmed by choice, then this also does not help them. So in that respect, it's not at all clear whether the remedies now really, in the Facebook case, are effective for exploitative and exclusive abuse. So in that respect, what we need also to solve the second market failure. And this means that competition law is not enough for solving this. And this is a very important point, that we need also data protection law and consumer law for solving the problem. And this is what I mean, that we have to also, need a more integrative approach between the both policies, and they have really also to collaborate with each other. So we need a collaboration between competition law, consumer law, and data protection law, and also the agencies have to collaborate, because what we need, if we have simultaneously two market failures, then we need a good combination of remedies for both market failures, and therefore we need this from different policies at the same time. And I think this is also an important lesson that we should also learn from that. It's competition law itself might also not be sufficient.
Exactly. Many thanks. Do you see, Sebastian, the same double market failure?
First, some short clarification because of this intervention of you. The Facebook case was just relating to off-platform data. I guess we should talk about this. This is typical lawyer stuff. Now talking about this is the case and this is not the case. It was not decided about this on Facebook data. Now we have to talk about the questions relating to this, but we don't. Now to your
but not only offsite. They're mixing the various
yes,
sources.
they are doing offsite together with onsite, or
exactly.
off platform with on platform. And that was the antitrust case, mixing together. Without mixing together, it's just Facebook. I guess we agree in this case that it will function like before. It's not the antitrust case in this way. Now my final remarks. First, I agree with Ioannis and Wolfgang Kerber, and maybe auch with Simonetta in one of the first sentences like this. We should assess more the factual effects of privacy and competition, but we should separate competition law and privacy law. The two law systems we should separate, but we should bring together the effects. And the effects are just empirical stuff. And the second one is just something in my mind. Maybe we should think about this, putting this idea in empowering the consumer more, giving more market instruments, or like from the grassroots, just to minimize the market power of platforms. Maybe this could be an instrument just empowering of consumers.
We're talking about that issue tomorrow, how to empower citizens more, when we talk about a new concept of data trust in Europe, or maybe some also connected issue of data altruism. Yeah, the final remarks go to, we start with you and we finish with you, Aline.
I'll give my best. I hope everyone's still awake. I think the remedies of the Facebook case can actually be really great if they're implemented well. And I would like to see them implemented more structurally across markets where we have the same problem. So I would like to see higher barriers for sharing data, sharing personal data internally, and that might even help to mitigate some of the effects of the GDPR which sometimes can actually favor concentration in certain markets. But at the same time, I also think it's important for competition authorities to also, well, move forward and think about privacy implications. I think at the same time it would be great to see more conditions that would help foster competition on privacy. And that's one of the points you mentioned. Yeah. In many cases, I mean, in many markets, we don't have concentration, but we still don't get proper privacy outcomes. And that's because we still don't have real transparency, even though we have a lot of provisions in the GDPR which haven't really been made use of. We also, well, we have portability in the GDPR, but it's not really made to work for competition. So I think we really need to think much more about real-time portability using APIs and so on. And only then I think we'll see more services that actually serve consumers much better and give more choice on privacy.
Final statements. I couldn't make it better. Many thanks for staying with us at 10:30. It was a really late night show, competition and privacy. I really enjoyed. It's hardly to imagine that the next session is in less than 12 hours tomorrow. But I really appreciate your presence. Especially many thanks again to our European guests, to Natalie, to Ioannis, to Simonetta. Let's get together in a Corona modus without alcohol. I really appreciate your time and many thanks. We see you tomorrow with the European strategy on data. Many thanks.